Be reminded if I'm nervous chomping on my
Well,
gum.
this is the thing. You just press.
Breaker 19.
All right, let's check. Are we on? Okay. Good to go? Well, welcome everyone. It is currently 6:33 as we're going to open our meeting. So I ask you to take seats. We're going to call to order. And at this time, well, that was not the way I was going to go with that. So maybe I'll get him on the way out. At this point, Councilman Brewer, since we are in our hopefully last meeting, would you lead us in prayer?
For this day, for bringing us the people here today who want to do good things for our community, and we ask for the wisdom that you have come through to us so that we can benefit our fellow neighbors. Thank you, Lord, for this day. Amen.
Thank you. You really stand, and I would ask at this point, Sherry London, will you lead us in the pledges? What? I didn't realize that. That is a pet peeve if there's ever a pet peeve. Good call. That confused me because I went right to where it was supposed to be.
I did too. I was like, wait.
All right. So before we begin today, I want to give a little bit of, takes a little privilege to explain what we're doing today in the process today. Today we will be we will be doing Robert's Rules of Order. We will be voting on all issues. In the past, we have been a workshop, which means I allow each one of you to talk whenever you needed to talk. Never been a problem. Today, I am going to ask for more order than I have ever asked. And in front of you today, you will have three colors. Yellow is to request to speak. That way I know that you want to speak and I can recognize you in order. And what I'm hoping to do is to write as we go so I get everyone accordingly in a time frame that's accurate. Now, we're going to be doing voting today, and we're going to be voting by color, and these cards, green will be a yay, and red will be an A, and we're going to vote all at once. The intent is so we're accurate and that we can get all the numbers. We're going to hold that vote for a minute so Ms. Hildreth can get all the votes, but that's important for the record. So these votes are counting. So also, anyone in the room, the quorum is expected. At first, I'm going to hold the decorum. I'll give you a warning if you get out of line and say, hey, we're not going to do that. If you continue to be out of order, I will ask you to leave. We are not doing this. Also, today we do have an audience. We did have the mayor. So I don't see him now, but he went in the back. But also, today, any questions we have Mr. Hollow, our city attorney. Any questions, we are going to make sure that we adjust them accordingly so we can make sure that we make the right decision for the future of our city. So if there's anything that might be out of order or any concerns, I will confer to him and we'll use that as that privilege. All right? So with that, we will now go to public comments. This will be an opportunity, anyone in the audience that wants to address this commission today, before we vote, to have your 3 minutes. We ask you to respect our time because we do have a lot to go through. And I just want to make sure that we do hear you, though, as your appearance and your is important and your voice is important. So anyone in the audience, left to right, would like to speak? Anyone like to speak? Anyone like to speak? Anyone like to speak? All right, please come up. I think we can turn the mic on.
Done this once or twice.
All right.
Awesome.
Can you please say your name for the record?
Donald Goodwin.
Okay.
And I'm at 1307 Sienna in Sonoma Verde.
All right. Welcome.
Go ahead.
Go ahead.
Just number one, I didn't realize how big of a group it was, so thank you guys. You guys taking your time. This is all volunteer work, and awesome. So thank you guys for putting your time into this. I actually took the time to read it, and you guys have done a great job. So thank you guys for that. I just had some thoughts reading it, just more from the finance brain. I would really like to see something kind of limiting the city's ability to borrow. Something, I kind of sent an email and they said, what kind of numbers? And I don't know enough about the city's numbers to talk about that, but maybe a 10% of revenue type of thing that the debt service can't be beyond that. Just trying to make sure that we're being fiscally responsible and not kicking the can down to future generations of McLendon-Chisholm. So that was kind of the thing that I was really concerned about as far as debt. But also anything else, I know we're kind of far down the road here, so anything else we can do to encourage fiscal responsibility in the city and kind of limit the city financially. Love to chat more with you guys about it. I just kind of wanted to throw that out there. Like I said, I know we're far in the process, so it's kind of late. But I appreciate all the work you guys have done. Thank you.
Thank you. So at this time, I will address the city attorney. On limiting the borrows, the languages traditionally do not address that issue as bounding a council. Can you address anything on that issues when it comes to that in the charter?
Yeah, like we would love to do it. That'd be fantastic. But we really can't, because you can't really limit a city's ability. It's like, oh, well, we need X amount of money. Oh, our charter says we can only borrow Y amount of money, so we can't really get this much needed thing, whatever it is, a lift station, pipes, that type of thing. They've got to be able to do what they need to do, and that would be potentially limiting future city councils on what they can't do. So, and to give you some encouragement, things like certificates of obligation have been, probably since 2015, have been very, 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 very contested issues. So what you can do is, okay, these are the things we're going to use them for. So we're not going to, whatever we use them for, it's kind of unabridged. We got to have the right to do whatever we need to do, no matter how much it is. But we don't have to say 74 things. We can limit it to 16 or whatever. So that's one thing that charters could do. Say a big example, certificates of obligation. Very, very briefly, they're kind of like, this is not exact translation, but they're similar to bonds that you don't have to go to have a vote for, but they're for very specific public types of things, not just for anything. So they've really limited that over the last few years, the state legislature has, but we can still further limit them in the charter, the different things that we want. I mean, it's pretty limited to public infrastructure, public improvements, things like that. So we can, while the numbers we can't, the subjects and types, yes, we can. No, it's on. No, it's. Well, those were a very, very hot topic with the legislature for a few years.
So, commissioners, as we begin and we get to that topic, if you want to look at that as we get to that process, you may consider that. All right. So, and thank you for being here. So, with that, is there anyone else that would like to speak? Anyone else like to speak? Anyone else like to speak? I am now going to close the public comment section, and we're now going to move to approval of minutes. So, at this time, we do have to vote on two sections. So, we have 4.1, which is the minutes for October 9th, 2024. Do I have a motion to accept? Yellow card.
Come on, can't pick up the paper.
Dennis Linden.
I make a motion or move that we accept the minutes.
We have a motion to accept the minutes by Dennis Linden. I saw Jody Wright have the second. Okay. All right. Very good. We have a motion and a second. All right. At this point, is there any other further discussion on the minutes? Leslie. All right. With that small correction in the minutes.
We think it's very important. That's how we feel here.
Very good. Just for the record, Holly, you weren't recognized. All right. So, at this time, I'm going to go ahead and call for your vote. Red is no, green is yea. Motion. Okay. You're going to have to go a little faster next time. All right. That was unanimous. All right. We're going to go to number 4.2, minutes for October 23rd, 2024 work session. Do I have a motion? Ms. Stibbins.
Motion to approve the minutes for the October 23rd work session.
We have a motion by Bev Simmons to approve. Do we have a second? Mr. Powers. Second. We have a second. All right, did I miss you?
No, I said second.
Okay, nope. I'm looking at there we go. All right. All right. Any discussion? All those in favor, say aye. Or green card? Sorry. All right. That was unanimous. All right. We're now going to be moving into our home rule draft. And so, before we begin, Mr. Holla, I want to make sure that we're correct in doing this. What I would like to do is, I think it would be appropriate, is I think that we can consider it as all one document and pull it out as a section, as which section, and then those that are, we can do it as a consensus vote, and then the remainder will vote separately. Would that be acceptable? Yes. All right.
I've got some comments on that, and I didn't get to read all of it today, but as we reach different sections, just some thoughts.
Okay. At this point, since I'm going to go to the first comment section. We're going to first discuss on Home Rule Charter draft, and I'm going to allow the attorney to make comments before we vote. So, Mr. Allah.
I just had, as you go by sections.
Okay, you'll bring things up. Very good. All right. We're going to go to number 6, discussion and approval of chapters individually inclusion. What I'm going to do is as a whole, I'm going to allow a motion to accept, and then we'll do it as one vote, and then we'll pull out the others, if that makes sense, the motion. So a consensus. So what we're going to do is I'm going to ask if there's anyone that would like to pull out for consideration, what they would like to pull out, or do you want me to go one by one and then we'll do it? Okay. So just at this point, put your yellow card up if you want that removed, and I'll take that as the consideration. 6.1, preamble. All right. I'm going to do it 3 times just to make sure that I give everyone consideration. 6.1, preamble. 6.1, preamble. 6.2, chapter 1, incorporation of boundaries. Incorporation of boundaries. 6.3, chapter 2, form of government and powers. Am I going too fast? All right, I'm going to slow down. We're going to pull chapter 2. 6.3 is the agenda item number? No, 6.3 chapter 2. The agenda item number is 6.3, and then pulling out. Sorry.
Cross-referencing.
Yep. All right. So chapter 2 will be pulled. All right. Chapter 6.4. Chapter 3, City Council. Pulled. 6.5, chapter 4, Senate. Yes.
Wait.
You have a discussion?
I have, yes. You wanted us to talk if we wanted to say something about that section, correct?
We're not there yet. We're not yet. What we're doing right now is pulling the ones for discussion. We're going to vote for the remainder of what we're not going to discuss, and then we're going to approve everything as consensus on things that we're not challenging. And then we're going to go back. So, Mr. Howell, can you kind of explain, because you understand what I'm trying to go here, because maybe I'm not explaining it well?
I think what you're trying to do is you're trying to get out of the way the things that people don't really are not going to disagree over. That way we get a big.
It's going to be basically a consent agenda, and we're going to approve basically I'll accept the motion to approve 6.1, 6.2, and those items as one vote.
Okay, but if we have a question about one of these, that's when we're
We're
supposed
going to
raise
pull it
our-
out, correct.
Okay, I would like
Now.
section 3 pulled
Just to
out.
pull it out, and then we're going to discuss it.
Does yellow mean pulled out?
Yes. Yes,
So we just
yes
raise,
means
we
pull it
just
out.
raise our yellow and you're gonna pull it out?
Yes.
Okay, got it.
Yep. I just need one person to say pull it out.
He's just going through the list on the agenda of every item that's there. And if nobody has any questions on it, you move down to the next one.
I'm
If somebody's
trying to
gonna
make
wanna
this go
discuss it
faster.
Later, you pull that out.
Huh? I tried really hard to make it simple.
That wasn't in my Wheatie box.
Ms. Wright.
Could we, thank you for that clarity, could we take a minute and confirm what's been pulled out then now that
Sure.
we're back on the same page?
Correct. So far, the only, chapter 2, form of government has been pulled. Chapter 3, city council has been pulled. We have not addressed 6.5, city manager. And apparently I'm starting to lose my voice. Okay, do you want to pull chapter 1? 6.2 will not be pulled. Okay. Anyone else? Okay. 6.5, chapter 4, city manager. All right, pulled. Chapter 5, city secretary. 6.6. Okay. 6.7, chapter 6, municipal court. Okay. Chapter 6.8, city attorney. You can raise your hand on that one, Mr. Allah.
Well, I did, 'cause I didn't see my name. So I was wondering about that.
Anyone on city attorney? Okay. 6.9, chapter 8, city department fiscal administration. Okay, so that would be, okay. All right. 6.10, boards and commissions. Okay. 6.11, chapter 10, ordinances. Okay. 6.12, chapter 11, elections.
I have a couple suggestions on that.
Okay. 6.13. Okay. 6.14, 13 franchises. Okay. 6.15, chapter 14, general transitional provisions. Okay, that can, so at that point. And then chapter 15, adoption of charter. All right.
Can we clarify
What's that? Go ahead. So right now, we're not approving anything yet. What I was going to do is ask if anyone has a motion to approve 6.1 preamble, 6.14, or sorry, 6.15, chapter 14, general transitional provisions, and 6.16, chapter 15, adoption charter. I think by seeing us having all this up, Ms. Wright.
I wanted to provide clarity, I got confused.
Okay.
I can pull out 6.6, chapter 5.
Yeah, it got pulled. It's pulled out.
I was one that requested that, it was in error, it's actually the one following it, so
Okay.
I was just saying that to get out.
Well, what I think we're going to go and do, because it's just going to be easier at the light we have, I'm just going to go through each one and just allow us to discuss it. It's easier that way. I meant to make it easier because I thought there wasn't going to be much, but listen, it looks like at this point, let's just do the right thing and go through each one. So I'm going to go ahead and begin with 6.1, preamble. Do I have a motion to approve the preamble? Mr. Powers?
I make a motion that we approve the preamble as written.
Okay. All right. And then do I have a second? Jody Wright. All right. We have a motion and a second by Jody Wright. Any discussion? All right. I call for your vote. Passes unanimously. Move to 6.2, Chapter 1, Incorporation and Boundaries. Mrs. Sorio? Am I missing you? All right, sorry.
Oh,
We'll get, go ahead, Mrs. Sorio.
I just had one
I don't have a motion yet.
Oh,
I'm calling for a motion. Mr. London?
I'd like to make a motion that we accept Chapter 1, Boundaries and Incorporations as written.
Okay. And do I have a second? Okay. And I'm going to go ahead and Mr. Adcox, I did see yours first.
Motion to second.
Okay, second. All right, we have a motion and a second. At this point, we have a discussion. Mrs. Soria.
Yes. Section 101 Incorporation, I had a suggestion to change from inhabitants to citizens. That is just technical. And also after, with such powers, comma, rights, needs a comma, duties, comma, that's a typographical.
Okay.
Which line are you looking at?
The typo?
Which line?
Yeah, at the bottom. Right here, with such powers, rights, there should be a comma and duties. Privileges, is mine different?
Yes.
Oh, is it in there already?
It's in under draft. Are you looking at the draft version?
No, I sent the one you sent me, but they should be the same, no? No. You said it would be the one we're voting on.
This is the copy that I'd be looking at.
I'm already drawn on this one.
Okay. So it looks like we do have, so are you making a motion to amend?
Yes, I'm making a motion to amend the wording from inhabitants to citizens,
Okay.
if so approved.
All right. So from inhabitants to citizens. Do I have a second?
Second.
Okay. So we have a motion and a second on the amendment. Ms. Stibbins.
Are you suggesting we change the inhabitants through this entire section 1 to say citizens, because it's in other places also?
If that's necessary?
I mean, if you want continuity, you've got inhabitants and citizens spread through this entire chapter 1. So if you want it one way or the other, just say make the change for all of them.
Just, yes.
Okay.
That is up to
Okay.
everyone to decide.
All right. So at this point, Mr. London, would you accept a friendly amendment or?
We're still in discussion, correct?
Correct.
So in section 1.03, section C, the second sentence says, the inhabitants of the annexed territory shall be entitled to all privilege or rights and privileges of all citizens. If we change all of the instances of inhabitants, that means that citizens will have the rights of citizens.
That's true, I don't know that it would apply. May I speak?
Yeah.
Okay.
Yeah, this,
I don't know if it would apply.
But give me 1 second. Mr. Powers. Oh, thank goodness for caps.
Not everybody who's within the city limits is a citizen? So do these things not apply to people who are sojourning through, staying temporarily, may not be citizens of the United States, may not be citizens of McLendon-Chisholm, but the rights that apply to the citizens absent voting, would they not apply to them as well?
That's going to be a question I'm going to ask our attorney.
So I want to make sure I understand the question. You're asking if people that are transient going through, they have the same rights as citizens? No, they would not, because they're not citizens. Nor should they. They don't pay taxes, they don't do, things for the city, they don't participate in this, they don't participate in that. So they wouldn't have the same rights as citizens.
All right, that's right.
Would it be acceptable to change inhabitants to residents?
Well, the point of the annexation part, they're not residents yet.
No.
That's the whole point, is annexation, they're just inhabitants of an area. They do inhabit that area, which is why they use the phrase inhabitant. Now, as soon as they're annexed in, then they become citizens / residents, however you want to say it.
Mrs. Sario.
That's what I was gonna say, Dennis, is wasn't certain that it applied to that section because they are inhabitants until they're citizens. The annexation section. But I have noticed, if I may continue, in many of the other charters that they do say citizens rather than inhabitants. It's not my new idea.
Okay. All right. Any other discussion? So we have a motion to amend. Do we have a second? We do have a second on the amendment. So at this point, to change the, Ms. Stevens.
Can I make a comment first?
Yes.
If you actually read that first paragraph, it talks about, it's talking about what may exist in the future, what exists now, what may exist in the future. So does the inhabitant word belong in that very first sentence? And then down in 1.03 section C, where it talks about inhabitants of the annexed territory and the privileges of all citizens, because the boundaries have already been established. Where in that first one, I think we're back to inhabitants is correct because it could be areas that haven't been brought into the city boundary yet. So I think that first one should stay inhabitants, and the citizen word comes into play later when it actually talks about the established boundaries.
Ms. Wright.
To that point, it is in section 1.03C, that my question of changing the inhabitants down the third line to the residents, because this is the completion of the annexation. So that was where I wondered if residents would fit.
And again, I think that Mr. Holla answered that, why it would be important to have inhabitants versus resident at that point.
Prior to annexation.
Correct.
But this is upon completion of the annexation.
All right. And I think the issue at hand is we do have an amendment for changing all language to citizen. So at this time, we do have an amendment on that. So all those in favor of changing language, or we're going to vote, and green is in favor, red is against. I'm going to call for your vote. Red is in favor, red is against the amendment. All right, that amendment fails. Now, at this time, there can be any other amendments or any other discussion. Any other amendments? Any other discussion on this topic?
I just have a question, I guess. Because that failed, the addition of the comma also failed then. So my question is, though, do we need to be fixing typos as we go through?
So
or is that-
I will correct that any language should be gone through the attorney to make sure that those corrections are made correct, Mr. Holla?
But so we don't need a motion for every typo?
Not every typo.
And that's
Well, you
okay.
can make it clear and we'll keep that in notes.
Substantive changes.
Substantive changes is what we're looking at.
That's what I assumed. I just
Very
wanted to make
good.
sure. Thank you.
Any questions on that? All right. Any other discussion? Any other discussion? Any other discussion? I call for your vote to approve the section. Seeing votes are unanimous. All right. Okay, moving to 6.3, Chapter 2, Form of Government and Powers. Do I have a motion to approve? Tony,
I make a motion that we approve chapter 2 as it is.
we have a motion to approve. Tony, we have a second.
I second the motion.
We have a second by Mr. London. At this time, discussion is now open. Ms. Wright, saw you first, and then Jen, I'll see you second. Yep.
I'm sorry. Under 2.02, Powers of the City, number 9. I'd like to get further clarity. This says to have the exclusive right to erect, own, maintain, and operate a waterworks and sanitary system. I'd like clarity on what the exclusivity part is.
Okay. Mr. Hollow.
What I would say the exclusivity part is, so you've got CCNs for water and CCNs for sewer. I know this is gonna shock everybody here, but many cities our size, glad you're all sitting down, run their own water and run their own sewer, okay? And so they've got it, the PUC basically says your city limits for a city is your de facto CCN. So you don't need to actually go out and file it with them, with the meets and bounds and all that kind of stuff. So what you don't want as a city, you don't want other people, if that's what you're doing, we're obviously not, but if that's what you were doing, you wouldn't want to let other people, other entities come in and kind of, you're protecting your turf, basically, is what that is. You don't want anybody else coming in and doing anything else and servicing your citizens and, doing things like that on your watch. That's what that is.
And my understanding of that, the CCNs that are current don't get impacted. The exclusive right of that decision still falls back to the city. If there's an existing CCN care, like Rockwell has other providers, but the rights of the city and the water decisions still lay upon the city.
They trump, basically.
Right. Yeah. But the CCNs are the one that manage. And there are other. You have a question?
So basically that's saying, if we ever want it, no one else can serve water or sewer in our city limits but us. Again, that's what many cities do, and it doesn't mean that we have to do it. We're not doing it.
And it doesn't trump the current CCNs.
Huh?
And it doesn't currently, the CCNs that are active are active. We still have to go through the process to acquire. Ms. Wright.
The language doesn't specify that it does not preclude the current CCNs.
Mr. Hall.
It doesn't need to, because the PUC has come out, they say, hey, look, your city limits is de facto, just means as a matter of fact. There may be no law passed, but that's de facto just means as a matter of fact, your a city's CCN is their boundaries, it's their city limits. So they have the exclusive right, if they ever want to, they have the exclusive right to serve water and sewer inside their city limits, no matter what any other CCN says.
Ms. Wright.
So if we played that out and assuming, taking anything that any of us currently know, when this goes to election in May, if this passed as this, and this now becomes the de facto CCN for our city, if we're adopting.
No, that's incorrect.
Already, right now, if we were able to, and I'm just telling you, most cities, the majority of cities that have 6,500 people in them do their own water and sewer. That's just a fact in Texas, okay? And what the law is your city limits is your CCN. It doesn't matter if you've got a home rule charter or not, your city limits is your CCN. So you have the exclusive right, if you choose and are able, you have the exclusive right to serve water and sewer inside your city limits. You do not have to, because obviously we don't. You don't have to, but if you ever have the ability and the desire, that's what it is.
Ms. Wright.
So thank you. I'm not trying to belabor the point. There's a lot of language with this, and I want to make sure I'm understanding it. So, assuming our charter passes, and let's say it stays as it's written, as it is right now. If in the month of May, the city of McLendon-Chisholm were to present and say, we now are able to provide our own water, which again, barring discussions, but just assume that were the case, that would then default, we would go with what the city is now saying they can provide, and that would eliminate getting water from other sources if we had that option.
No.
We have, hold on, we got an option now. If the city council
If the
wanted
city
to,
could.
if they could provide water and sewer,
Right.
the charter is totally irrelevant to that.
Correct.
If that helps. That
Yes.
could happen right now, so whether or not you pass a charter is not,
Basically, it just codifies the simple language that it basically codifies that issue. And again, CCNs, there are municipal requirements to acquire CCNs and everything else, and that process. The charter doesn't address that issue. All right, state law
right.
handles that. Mr. Dean.
I think what you're trying to get across is very important, because we want this to pass in May.
Thank you.
And if the average McLendon-Chisholm citizen read that, they would think, what the heck is going on here? And I understand all the CC, but they don't. That's all I'm saying is, I would be in favor of putting something in there that kind of, I guess, kind of eases their I just think we want to get it passed.
Tony?
That we, from my understanding, we're gonna have, town hall meetings, we're gonna educate the public.
That's correct.
Here, it will be up to us, or be up to that point, to make sure they understand it that way. What we're doing here, what I'm seeing here, and what I'm getting from it is we're making plans for the future. We're not gonna tie down a city council, because of language, because of what we're afraid of what our current status is right now. So that's just my thought, is that since we're doing the town halls, that it would just be up to us to educate them on every bit of the charter to make sure they understand it. But I see the point, though. I mean, I do understand it.
And again, I'm going to remind you that it is going to be our duty it's going to be part of our job to make sure that we educate, and also, so that our job isn't going to be done. This is our big job, but our job still continues. And when people come to ask you these questions, that will be our job to inform. All right, Ms. Huldreth, I saw you.
I just want to be clear, just because I may not be getting it. Okay. So the CCNs are already in place for the city of McLendon-Chisholm.
Okay, so a CCN, no, look, it's very complicated. Okay, the PUC hasn't even figured it out. So please don't think you're asking a bad question at all. It's ridiculous. It's almost like they go out of their way to make it complicated. Okay, so a CCN is a certificate of convenience and necessity. It is actually a descriptive in metes and bounds that's filed with the PUC. And so it gets a certain geographic area, and whoever it is says, hey, look, PUC, I want to serve water or sewer, whatever one it is, but I want to serve one of these in this geographic area. The PUC does their thing, sends it through 87 boards and commissions, and goes through all this kind of stuff, and they approve it. So that entity, whoever made the application, they've got the exclusive right, which they protect themselves. I mean, if you run a business, you don't want competition. So you've got the exclusive right in that defined area to do water or sewer, whatever it is. When it comes to cities, and it doesn't matter if you're home rule, general law, whatever, the PUC says, hey, I don't care if they file anything with us, a city's boundaries, their city limits, acts as that city's CCN. So if the city ever decides that they want to have exclusive water or sewer service inside their city limits, they don't need to make an application to PUC. They've got their city limits. That's what the PUC has said. Does that help? Okay.
Okay. Leslie?
So I actually have a question about this process, not about this specific item. Can I ask it?
Right.
So we go to the public, we do town halls, we get public feedback, we get public comments. Is there an opportunity to address them and possibly edit? I mean, if say for this issue, if it's clear coming out of the town halls that this could cost us the vote or whatever, do we reconvene and vote to amend it at that time?
Here's the thing, you can do almost anything as long as it's on the agenda. We can set it up, not just a town hall, we could have we could label it citywide discussion on the agenda between the Home Rule Charter Commission and the public regarding, and then exactly the way you got it on the agenda now. And then there can actually be an open discourse and discussion. It's just simply got to be on the agenda that way. So yeah, in answer to your question, we don't even need to wait, hear it, come back, address it, and go back. No, we can talk about it all at once.
Okay, so what we're voting on tonight, our intent is that it's what's on the ballot in May, but we have opportunities to change it if we want to.
Absolutely.
Okay.
Yes, that's a great question. I hope if you get feedback and you have 91 people that show up and they go, hey, this section here in 18-11, it sucks. And 87 people agree. Hey, you know what? 87 out of 91 says that, or 88, because 88 out of 91 says it sucks. We may ought to consider changing that. I would hope you didn't have to, but okay. Yes.
Okay.
Absolutely.
Mr. London?
So the CCN, everything gets approved. We have our limits, but PUC has to grant us the authority. We would have to have the ability to receive. We would have to prove that we have all of the capabilities and everything associated before PUC or TCEQ would even consider allowing this to move forward past just the words. We can have the words in here and have this written for our authority that we have the exclusive right. And correct me if I'm wrong, Mr. Halla, but right.
I'm simply talking about the right. What Mr. London is talking about is the ability, and I don't disagree with you.
Does that make sense?
Would it help to put in, according to law, according to current law, some language in here amending this to sort of just address that it's nothing outside of the law, or?
I mean, you can add something there, a prepositional phrase like in accordance with law, something like that. I mean, I don't think that's a problem.
I'm wondering if the attorney is recommending that we accept the language of item 9 as written. The one we're talking about right here, item, yes, sir. Are you recommending to us, based on your expertise, that we leave the language as written?
I don't have a problem with the language as written. It doesn't let us do anything after it's passed that we can't do now. Now, what McLendon said, the ability is completely different. The rights are still the same, and the ability, we don't have the ability now, and we may not have the ability after the Home Rule Charter. So
it's your recommendation to leave the language as it is?
It's up to y'all if you want to change it from a legal standpoint. I have no issues with the language now.
Okay, I'm not sure I'm understanding what the confusion, what the issue is. Because you were saying that if the language, that could cause it not to pass. Is it the word exclusive? Do you think people are going to think that we have to do that? We now have to do that? Because this is there? That McLendon has to take care of the water and the sewer? Is that is that the way you're looking at it? Maybe we just need to take out the word exclusive.
Example, and Mr. Hall, help me out if I don't. There's another example of exclusive right, public safety. The exclusive right to your public safety is a police department. Is exclusive right to public safety is the municipality. You can contract and you can use other law enforcement such as the sheriff. But the exclusive right to protect the city typically falls under the city. How they provide that safety, by contract or by agreements, that interlocal agreements, is up between the two parties. That would be the other example.
To build on that,
Yeah.
I do want to leave exclusive in there. For example, would y'all be comfortable with HOAs hiring private security forces that patrol the city that work for them? I mean, probably not if we've got 16 little private security forces made up of, 6 or 7 highly trained Green Berets, Rangers, Navy SEALs, whatever, that patrol it and just answer to those 6 or 7 groups. That probably wouldn't be the best. Say, like what Chairman is saying, the police force, if we had one, the police force would be the one that would have the exclusive right to govern that. All you're doing with the word exclusive is protecting yourself. So if in the future, if you're going to run a water business, you're going to run a water business. You don't want people coming in and stealing customers or anything like that. You want the city to be the one that runs the water, has the water, charges the water, sets the rates, do all that kind of thing. You don't want 14 people in here servicing water, and you've got 14 groups of citizens that are answering to 14 different people on the water rates. So you do want to make it exclusive, if that helps. Right. Oh.
So maybe the compromise is to, you would need to have the exclusive right to erect, own, maintain, contract. So own or contract, maintain and operate. To add out the.
I think you've already got that, but I don't have a problem with adding that in there.
Because you can contract it out, right? Because then that's verbiage for the town hall that you can say, but it also says that there's, I don't know.
I think contracting would be part of maintaining it. How you maintain it as a city, if you want to hire somebody to run, and there are a few cities. I did help one city do a contract where they sold their water to a private entity for $9.2 million. And they were tired of being in the water business, and they sold it, and they obviously paid it off either a month or a year. Before that contract was final, they had a contract with that same company to maintain the water system. So I think contracting someone to do that is under maintaining. But I think your question is a good one, and it's legit, but I think it's covered by maintaining. That's just how you want to choose to maintain it. If you want to contract out, that's fine. So it's a good question, but I think it's covered.
Like this, we have to, sorry. Is this on? Yeah. If we leave it like this, we have to add something. Can I give an example? It'll make it easier.
Mr. Howell, you want to, okay, so I'll reiterate, Roberta, basically what she was saying is the contracts, that it would be someone that would be out of the area, such as another municipality, and the control. The issue with that is what this is the exclusive right of all controls and decisions of the water rights come back to the city. What you're talking about is different in the matter, all right? And again, that provision in that communication. The other thing that I would address to that is when at a period when municipalities could annex by forceful annexations, which cannot by state law right now, they would acquire
a total of 7 months. I think Trophy Club had a good, one. I don't know where I put it, but do we want to state when the meetings will happen? And how many?
Do you have a recommendation of an amendment? Okay.
I have so many papers and notes. Okay. So I'm making a motion to amend Section 3.07 meetings and quorum to say the council shall hold at least 2 regular meetings a month for at least 7 months and a minimum of 1 meeting during each other 5 months at a time to be fixed by council for such regular meetings.
And you went at the beginning of the regular meetings of that paragraph, correct?
But, yeah.
Okay. We have a amendment. Do we have a second? Ms. Wright.
Oh, sure. So we're at 3.07, and it just states regular meetings, but it doesn't really say what that means. And looking at Town of Trophy Club, they have it written as, the council shall hold at least 2 regular meetings a month for at least 7 months, and a minimum of 1 meeting during each of the other 5 months, at a time to be fixed by council for such regular meetings. There's more if you want me to read it, but that was the part that I was putting in there. They say council may hold as many other meetings as may be necessary for the transaction of the business of the city, but I don't think we need to add all that in.
Okay, you have to clarify, we're in a motion amendment. It has to be direct language,
Okay.
ma'am. I'm sorry.
I'm for it. So you want me to read the exact language?
I need you to put the exact language that you want submitted.
The council shall hold at least 2 regular meetings a month for at least 7 months and a minimum of 1 meeting during each of the other 5 months at a time to be fixed by council for such regular meetings.
All right. Do I have a second? Motion dies due to a lack of a second. All right. Any other discussion? Mr. Brewer.
I'm just speaking because I was asked to pass along on this area on 3 about the duties of the mayor. Mm-hmm. There was a concern that there wasn't enough spelled out for them, for that person. And although that language that's in there is probably the language that's in, I think, in every charter in Rockwall, there was language in the one recently passed charter, which was, I think
Liberty
I
Hill.
forwarded it all to y'all on Liberty Hill.
Mm-hmm.
I think if you actually read through the document, it does specify what the mayor says. But as I said, I'm passing this along, and
Okay.
I actually did make copies of what Liberty Hill has specifically for the mayor. So I'm going to pass that along, let you look at it. If you want to add or not, it's up to y'all. I'm just the facilitator here. That's it.
So, Mr. Howell, at this point, since we're in, unfortunately, outside comment out of that is not acceptable. But I will accept the Liberty Hill, and if any of you want to look at that. But any outside concern, that's closed. So I'm going to say that's out of order.
Okay.
So, but I will allow you to pass out the Liberty Hill. Ms. Stevens.
I have a feeling he got the same phone call that I got, and that's why I wanted to have the mayor added into the council duties in the very first section, because it did look like that we were not giving our mayor anything to do. But by stating that the mayor is part of the city council duties is long. So now they're all should be even and equal.
Okay. So under section 3.4, you're basically, I'll allow a motion to amend. At this point, we're still in this section, so it's acceptable. We haven't moved on. So if you want to include that, there can be a motion to amend. Mr. London?
I'd like to make a motion to amend to include what was just handed out from Liberty Hill, Texas Charter for the mayor powers and duties.
All right, we have a second? Is that all right? We have a second? All right. Discussion. Yes, here's what I would like to do. I'm going to recess 5 minutes for you to allow to review this, and then we'll go back to it. So if you want to read it, you can, and if not, but I'm going to give, I think that's a fair compromise. So we are recessed for 5 minutes. 8:23, we call them back to order. So I'm going to ask at this point, has everyone had sufficient time to look at the Liberty Hill Charter Amendment duties of mayors, which we have as amendment? Mr. Dean? Okay. All right.
I'm sorry, where are we on?
We currently have an amendment to accept the Liberty Hill duties at 3.04, which has been submitted to each of you. Ms. Stibbins, discussion.
Okay, so under section 3.04 that we have right now, section A already addresses number 1 and number 3 of the Liberty Hill duties. Number 7 appears later in our boards and commissions section, and we already beat to death number 8 on the special meeting. So there's a few of these that probably should not be repeated.
Okay. All right, Ms. Osorio.
Yeah, in, let's see, number 4, section 3.09, I believe, addresses this. I just had it. You saw it too? So we should look at number 4, yes?
It does, you're absolutely right.
Okay.
When we talk about disasters, so
And
4
number,
can come out.
number 6, well, so we're a council manager, home rule is what we're going towards. So I feel like some of these things are put to the city manager.
So 6, explain, and I'll explain, Mr. Holla, when it means the resolutions, orders, and signs, the ordinances, there is a section where the mayor signs it. And so when you have a resolution, the mayor signs it. What that is stating is that he may sign those ordinances or the contracts. There are sometimes where the mayor will sign a contract procedurally. Sometimes it might be if you were to get a grant or something like issues where they asked for the mayor to sign it, it's the procedural point of that. That's all that's saying. It's making it clear that they have that ability. The may, it's a may, it's provisionally may, not required.
Okay, so
Would that be correct, Mr. Holla?
I mean, honestly, it's a bit superfluous because the mayor can already do that anyway. So, but I mean, it's not incorrect, I'll put it that way. If that helps.
Chair recognizes
No, the mayor, the chair does not. Mr. Powers, you are now recognized.
Does anybody see anything on here that is not included in what we already have that we'd like to add? Sounds like we got a lot of it already included. Is there something that stands out to anybody that we don't have yet that you'd like to have?
Mr. London.
So in the amendment that I had previously made that we're working on now, I had said as written, may I make an amendment to my amendment? It is my amendment after all.
Yeah, you may.
Okay. Then, according to the discussions that we've already had, I'd like to strike 1, 3, 4, 7, and 8 as they are redundant. That's 1, 3, 4, 7, and 8. The other areas of 2, 5, 6, 9, and 10 are not covered unless somebody finds something that we have overlooked.
So to clarify, you're making a motion to include language of 2, 5, 6, 9, and 10.
From the Liberty Hill, Texas Charter. Right. That is correct.
All right. And then who was your second on that again? Rich. So do you accept that as the amendment? I don't believe so. Okay. Very good. So again, that has been accepted as a friendly amendment, has it now been amended to include the language, to include, which I'm gonna have to figure out, how to make that fit. Do you want that language? Yeah, so, to make that fit, friendly amendment?
Friendly amendment.
To include it as now 2BC, D, 5, 6 is E,
May I make a suggestion? If you leave A the way it is, under 3.04, and then make B duties of the mayor, and then list these things as subsets. So B1 would really be B2, would be 2, and go that way. Follow me?
A1, you mean?
And yeah, so what is B right now is going to become C by itself. So under B, you would take item number 2 of Liberty Hill. B would become duties of the mayor. And then B1 would be number 2 under Liberty Hill. B2 would be 5, and then 6 would be 3, 4, and 5. You'd have 5 duties of the mayor under under B.
Okay, so the city here adopts enumeration of specific powers exercised by the mayor, B1, 2, 3. Do you accept that amendment?
I accept that amendment.
All right. Mr. Dean, is it still? Okay. All right. So with that being said, we do have friendly that is accepted. And so now, amended that we're going to add a section B, which will say the city hereby adopts, and then the numbers of the language that has been discussed. Any other further discussion? Mr. Powers.
I would like Mr. London to repeat his amendment in full on everything that's going to happen that's been discussed now.
Okay. Congratulations.
All right. So I propose an amendment to section 3.04, mayor and mayor pro tem, to include the sections of the Liberty Hill, Texas Charter to become section B, which will be the mayor powers and duties. The city hereby adopts an enumeration of specific powers that may be exercised by the mayor. B1 will be what is number 2 now. He or she shall work closely with the council to obtain legislation in the public interest and with the city manager to ensure that the same is enforced and participate in the discussion on all legislative and other matters coming before the council. B2 will be number 5. The mayor may administer oaths of office, i.e. swearing-in ceremonies. B3 will be the mayor may sign ordinances, resolutions, orders, statements, contracts, deeds, conveyances, easements, bonds, plats, and other documents as directed or authorized by the city council, except as delegated to the city manager or designee. B4 will be number 9. The mayor shall be responsible for providing initiative and guidance in the orderly management and growth of the city. And then B5 will be the last one, number 10. The mayor may exercise all duties conferred by the Texas Constitution, state law, city ordinance, city resolution, or other applicable law.
And to clarify, the current B under 3.04, mayor and mayor pro tem will become item C.
That is correct.
Thank you.
Okay. Any other discussion? All right, I'm going to go ahead and call for your vote. All right, motion passes. Great job, everyone. Good job. Is there anything under Chapter 3, City Council? Mrs. Sario.
This is short. Very quickly, under 3.11, prohibitions.
Yes.
It's really just a typographical, section C. It says, City Council and its members shall hold the city manager responsible for proper administration of all affairs of the city, but neither the City Council nor any board or commission created it. And it doesn't, just the sentence doesn't make sense to me. By it.
Okay, we'll put in the word by. Mr. Hall, I think I can accept that as a friendly clerical amendment, doesn't need anything. So we will accept that as a clerical adjustment, not a vote at this point, because that is a clerical error. So that will be under 311. C. Where the language will be, no member shall give or, it would be the third sentence or first sentence, but the paragraph, but neither the city council nor any board member or commission created by it. And so we will take that and we will include that and correct it. Any other discussion? Easy fix. We tried, we had a team, but it happens.
We are a team.
That's right. Any other discussion on chapter 3? Any other discussion on chapter 3? Okay, we will now call for the vote on chapter 3. It passes unanimously. Very good, everyone. All right, we now move on to C5, chapter 4, city manager. Do I have a motion? Leslie.
I move we adopt chapter 4, item 6.5, chapter 4 as written.
We have a motion to accept. Second?
Second the motion.
All right, we have a second by Bev Stevens. All right, we're now into discussion. Any discussion? Ms. Stevens?
Mr. Dean, this was the hill I was going to die on.
That wasn't discussion. Out of order. No. Any discussion? Any discussion? I now call for your vote. Passes unanimously. Thank you. All right, that moves us to 6.6. City Secretary, do I have a motion? Ms. Wright. Excellent. Mr. Powers. I second that. We have a motion and a second. Discussion. Ms. Stevens.
I have one question.
Yes.
Under the duties of the city secretary, number 3 says administer oaths required by law. We just gave that power to the mayor. Can it live here too? I'm fine with it living here. I just wanted that it does now live in 2 places.
So I do think that administer oaths, but I think it's still permissive that she may, Mr. Halla, I want to be clear that she may administer those oaths that the mayor does not want to. It's still a power that she has. Correct.
It doesn't say may, it says shall.
Well, I think that she shall do it if she's.
Okay, I just want to make sure we're comfortable with it being in both places.
Mm-hmm. All right, Mr. Powers.
I believe under the mayor, it's the word may is used, and on this one here, the qualifier is required by law. So anything that would be required of him or her.
Correct. No. That's correct, Mr. Powers. That was the way I understood it as well. Yep. All right. Any other discussion? Any other discussion? Any other discussion? I call for your vote. All right. Congratulations. All right. We now move to 6.7 Municipal Court. Mr. Hall, did you have a concern on 6.7?
I just thought on the municipal court, I just had some suggestions for some language is all.
Okay. Mr. Hall, what I'm going to do, just to get it through, to mouth out the suggestions, I'm going to allow us at this point, do I have a motion to accept 6-7?
Yeah.
Mr. London?
I motion to accept 6-7.
Okay, wait, do we have a second? Tony, second? Okay, we're now open to discussion. Mr. Hall, I'll allow you to make any recommendations
So it
or
wasn't,
suggestions.
I just thought it was a bit thin on municipal court. And so I came up with there shall be established and maintain a court designated the municipal court for the trial of misdemeanors with all the powers and duties that are now on or may hereafter be prescribed by the law of the state of Texas relative to municipal courts. B, the city council shall appoint a qualified municipal court judge and a qualified associate judge who each will serve a 2-year term. As we grow, I would expect us to, because it's been a while since I've done anything in municipal court, I expect that we're going to grow and, again, the charter, some of the provisions in the charter may not be relevant here and now this second, but you want them in place in the future because you expect that at some point you're going to be utilizing those. In the event the council does not make said appointments to fill said judge positions, the municipal judge or associate judge who is not reappointed by the 91st day, absent action by city council, shall continue to serve for another term of office beginning on the date the previous term of office expired. In the case of a disability or absence of the municipal court judge, the associate judge shall act as judge of said municipal court. The judge of said municipal court and associate judge shall receive such salary as may be fixed by the city council. There shall be, and this is something that wasn't in the last one, there should be a clerk of said court appointed by the city. The clerk of said court and his or her deputy shall have the power to administer oaths and affidavits, make certificates, affix the seal of said court thereto, and generally do and perform any usual and ordinary acts that are necessary to be performed by the clerks of the court to issue and process the said courts and conducting the businesses thereof. So what clerks do, they'll take affidavits from complainants, affidavit from police officers, whoever's making the complaint, and you swear to that clerk that the statement you're making is going to be the basis for a complaint, which is a charging instrument that will use the municipal court. You're swearing and affirming that everything you're saying there is true to the best of your knowledge and belief. So those would be the oaths there. They're not talking about the same type of oaths that we're talking about there. But that's who you're going to be swearing to when you go into municipal court and have a complaint. So you need a clerk. Somebody's got to do the paperwork. Somebody's got to keep it organized. Somebody's got to know how many tickets there are. Somebody's got to know who's going to coordinate when we're going to have a court date, who's going to do what, all that kind of stuff. So this is more of a full and complete court than what we had before. What we had before wasn't wrong or bad. Like I said, I just thought it was a bit incomplete.
Mr. Holla?
Oh, yeah.
Have you seen the Heath version of the municipal court?
I haven't seen Heath's.
So I'm going to hand to you, and I'm going to ask you a question. Do you think this would be the acceptable language? I can show you. Okay. Got it?
And I have another question. In the past, the city secretary has acted as the clerk of court. Do we need to go back to section 502 and amend her duties to include that?
That is a question for the city attorney. I'll ask that. I think it's clarified that it doesn't, because it could be whoever that the city manager appoints. If we did this language in 6. So. I'm trying to make this a little easier, so if we adopted the language, then I have something I specifically can use to adopt. Because I think this is exactly what you're saying, Mr. Holla.
Yeah, I mean, they added 6.04. I mean, that's going to be laid out in Chapter 45 of the Code of Criminal Procedure.
Correct.
What their jurisdiction is. But I don't necessarily, as long as, I'd have to go look to make sure, but I would want to make sure it's complete and didn't leave anything out. Assuming that 6.04 doesn't leave anything out, it's pretty much what I had plus 6.04. So, yeah, I mean, I don't have an issue with that.
So, I guess at this point, Do we have any official, Leslie?
I just want to understand, and I apologize, I think we talked about this the last time this came up, but if someone could explain to me again why we said they shall establish a municipal court and not that they may?
Your ordinances, you have to have a court with your ordinances and other things. The way I understand it, you do currently have a court.
We do currently have a court?
Yes, we do currently have a municipal court.
No idea.
Just, if you did not know, Mr. Paul Liston, Judge Liston, is your municipal court judge at this time.
So what I think, now, one quick thing, I'm glad you asked that, but of course I would want to know, like, why wouldn't you want a municipal court? Now, here's where this is a little different. We need to think about this. So under chapter 29 and 30 of the government code, those cover courts of record and courts not of record. Okay, we're right now not a court of record, which means that anytime we have a trial, we've had trials here before, anytime we have a trial, there's a defendant, they come in, whether they're guilty, not guilty, that's what a judge decides. So when they're guilty, they want to appeal it up to the county court. It's called de novo. That's just Latin, basically means of new. It's a whole new trial up there. Everything is new. The evidence goes up, witnesses go up, but they do it up there at the county. Okay. Now, every general law city starts out as not a court of record. You can, by ordinance, a general law city can become a court of record. And it's process, and it can be, there is a debate on whether it actually is a benefit to the city or not to be a court of record.
Right.
Okay? So, but you got to pass it by ordinance, and your judge has to be an attorney.
Correct.
Okay.
That's the difference, is that your judge does have to be an attorney, and you pay that the cost of that does go up.
That's what we'll be doing
Versus.
with this ordinance. That's what they're saying. By ordinance, create and provide for a municipal court. Technically, we already have a municipal court. As soon as we were incorporated under Article 11, Texas Constitution, we had a municipal court. The mayor is actually the de facto judge of the municipal court. Okay? So here, I think what they're talking about, the way I take it is, now they're making a decision to be a court of record, which now means when you have that same trial, there's a court reporter that's taking down everything. And you don't go up there, the defendant doesn't go up to the Court of Appeals, doesn't go talk to the judge, doesn't cross-examine witnesses, doesn't have a whole new trial. They take that record that the court reporter made, they put it into a big old sack of stuff, depending on how much talking was going on and how many exhibits there were, and they send that stack up to the Court of Appeals, and that's what they make their decision on, is that stack of paper. So that's kind of what's going on with the creation of the ordinance portion. That's what it looks like to me.
I don't think this one, I didn't see that it said it was a court of record.
Well, but my point is, because we're already have a municipal court, as soon as we were created, it says by ordinance, create, provide for municipal court. I'm taking that as, because they didn't need to do that. That's it's kind of silly to have that there, because the government code already gave us a court of record as soon as we were incorporated as a city. So it's kind of silly to say we're creating a court of record. So creating a municipal court. So really what they're probably doing there is creating a court of record.
It doesn't imply that it's explicitly, though.
No, but it makes the most sense. They already have it. They already have a municipal court. So why do they have a phrase in there that says they shall create and provide for a municipal court? If they've already got one, why are they
So
doing
do you
it?
think we should adjust it accordingly and say just basically, so do we just not allow the creation then?
I mean, the way I got it is the court shall be established, there shall be established and maintained. That doesn't mean create. It's already there, but we're going to establish it. We're going to have a designated place for it because we're going to have a clerk, we're going to have a judge, and we're going to maintain the court.
All right. So do I have a motion to amend? Because right now we're just discussing. The recommendation.
And y'all can leave it as you want. I just think you need to provide for judges a little bit more, and then also the clerk of the court.
All right.
Point of clarification.
Mr. London.
Is the suggestion for the amendment now, or is this an actual amendment?
No, this is a request. It's not, no amendment has been made. He's only making legal suggestion. It can't be accepted except by a member of this commission. Is that right? Mr. Adcox.
I motion to accept the Heath Charters Municipal Court, Chapter 6.
Do you want to add with that, with that first sentence be shall be established and maintained? Or do you want to as it's written? Because I think that's the intent he's concerned about, is you're creating a court of record.
With the revision as per City Council.
Or City Attorney.
Establish and maintain.
Okay. All right, we have a amendment.
With the revision to establish and maintain, right?
Okay. So what it would read on that first creation, the City Council shall establish and maintain a municipal court. And the rest of the language will be, and may appoint one or more municipal to serve in the court. Correct? So everything else stays the same, except for that language. All right, Ms. Wright?
I move to second.
Okay. We have a motion and a second. Any other further discussion? Mr. Powers?
So are we?
No, I mean.
Are we adopting all of Heath's language or just the portion you read?
With the exception of the first sentence being that the City Council shall be established and maintained.
Okay, we're adopting all of it except for that. Got it.
All right. Any other discussion? Ms. Stibbins?
Are our city attorneys in agreement with this?
Yeah, I mean, the Heath is pretty much what I have here, so.
Okay,
yeah.
I just want to make sure that all the language that you rattled off earlier is in there.
I like to say read off, I'm a rattle, but.
Just to clarify, we are striking the language as written in its entirety and replacing it with Heath.
No, they pretty know what.
That is, at this point, that's what is being suggested.
I just want to make sure. Okay.
Yes. We're going to strike the whole language and put this section in as whole. And I probably should make sure, since we're making those changes. No, don't do that. Stop it. Out of order. Any other discussion? I can't even turn off his mic. That's the problem. Yes. No, we're in discussion.
Okay, so, trying to make sense, so this means we will become a court of record?
No. The language has changed to avoid that. That is exactly why we put the established and maintained. Yep, that was specifically. And I think at this point, I think courts of record, to what Mr. Hollis said, I think courts of record, trial de novo, it gives people opportunity to go up to a higher court if they so wish. But I think courts of record, too, that debate, attorneys, I do think in smaller cities, it makes it difficult to have the affordability of that in a small city like us. I think that becomes limited, in my opinion. That doesn't mean attorneys aren't good as judges. That's not what I'm saying. I'm saying the cost towards a smaller city could be.
I'm not necessarily in favor of courts of record, to be honest with you. After 25 years and doing municipal courts for I don't know how long, I mean, I give you a great example. I know the judge in a particular city and I didn't have a problem with him coming on, known him for a number of years, but now that city complains about the same thing, that I don't charge them enough, but one thing that's having to go on in that city is there is more cost for municipal court because they're a court of record.
Correct.
And this judge is doing things, a bit differently. So I'm a little irritated because I'm not convinced it's really saving. And I've been representing the city for 17 years, I think. I know I don't look like I'm doing it alone, but it's true. It's true. And so I've kind of like with y'all, I feel a little protective of the city, and so I'm not really necessarily a fan, so I'm kind of glad y'all didn't necessarily say, hey, I want to be a court of record.
So, and here's to that point, and I will say from the experience of the chair, that you have people who can go rogue at any level, and power can go to anyone's head. And I would just say that.
Even like chairs of home rule charter commission.
Yeah, crazily enough.
It's crazy.
Thank goodness. But, oh, you're agreeing with that one? Thanks, Dean. All right. No, what? Thanks, Powers. All right. All right, so any other discussion on this matter? Any other discussion on this matter? Any other discussion on this matter? All right, we're going to call for a motion on the amendment as submitted. All those. All right. And the vote has been accepted. All right, so it is now amended the full chapter. Now we must go back because it's an amendment. We now must vote on that chapter. All those in favor of the chapter, vote. Congratulations. I like when a plan comes together. But that's okay. I'm good. Listen. Again, I'm going to take a little executive privilege as we go in here in this length. We are starting to move along again, back on track, and I want to say that is why I'm glad. And we're going to go into our next one. We're going to go into city 6-8, chapter 7, city attorney. City attorney. Do I have a motion?
I make a motion to accept chapter 7 as written.
We have a motion, chapter 7. Do I have a second? Roberta? Second. Okay. We have a motion and a second. Discussion. Mr. London.
I thought previously we had a discussion that we were going to include some language about, and maybe it's somewhere else, the city attorney shall be present during discussions and special meetings that specifically involve legal matters.
That might be an accidental omission, and that would have been an accident if that was the case. But as it is written, would you like to make a motion to amend?
We kind of beat that one up. Yes, I would like to make a motion to amend Chapter 7 to include Section 7.04, that the city attorney shall be present during any council discussions or votes where a legal precedent will either be set or, what was the word we used for, or removed. I can't think of the words that we used.
So you're making it a 7-4?
Correct.
Could we find it in the minutes? I don't know if I can talk, actually.
Mrs. Sarah. I'm sorry. I was looking
No
here.
problem. Can we find that language in the minutes, perhaps?
I was just looking through these minutes. I didn't see it in here. Oh, it's in older minutes? I didn't bring my older minutes.
So we have a amendment by Mr. London. Do we have a second, Mr. Dean? Okay. All right. So we have an amendment. Do we have a second on the amendment? Leslie? Okay. So we now have a second. Now we're in discussion of the amendment.
It seems like that's a 7-3.
Right.
So are you making, and I'm clarifying here, clarification, are you saying that you want to say in that duty, attend all city council meetings? So I guess that's the question that's up to you, because that's not technically under that.
Are we still in discussion at this point?
We're discussion of your amendment.
Okay.
And
the
he's
reason,
asking that.
okay, so we could put that under the duties of the city attorney. I'm just trying to have this as something specific to any legal precedents that may incur during any council meetings or special meetings. And I'm using specifically what happened on September 17th as my example. Unfortunately, Mr. Holla had another appointment, was not able to be here, but yet our city council made a legal decision that went against even my understanding is Mr. Holla would have recommended them not to take that vote and or to have further discussions. I'm not trying to put words in Mr. Holla's mouth.
I think that would be out of order at this point. So,
okay.
Yeah, that's improper discussion at this point.
Okay.
I think the question is, to that, I will ask that, is that, Mr. Holla, if you shall be the legal advisor and attorney for all departments in the city and shall represent the city in all litigation and proceedings, that, and then if we say that, be the legal advisor and attend all meetings, that would that address the issue? That be present at all meetings?
I mean, I mean, sometimes it may not be practical. What happens if the city attorney is sick, or what happens if the city attorney was already out of town? So you may want to, you could put somewhere in the charter that to address what you're talking
Except
about.
for illness?
That, yeah, they won't have those items on a meeting without the city attorney being present.
Okay.
I would accept that.
Okay. Oh, okay.
So a friendly amendment?
I think so. And
That
I
would
think
be under a part where we've got like agendas and meetings and something like that. That's where we would look at it there.
So not under this section.
I think you could put it underneath that. I do. I think it'd be more appropriate under the meetings specifically, because you want to know for the meeting, if somebody's looking at the meetings, well, wait a minute, okay, here's something specific. If this is going to happen at one of those meetings, then we can't decide unless the city attorney is here. So, because that wouldn't really be one of the city attorney duties or anything like that. It wouldn't fall under appointment or compensation or anything like that. So I think it'd be more appropriate under meetings. So, hey, if somebody, they're not going to go directly necessarily to the city attorney. They're going to go look, was there anything in the charter that says that we can't discuss this at a meeting?
Right.
Oh, right there at meetings, it says we can't do it without the city attorney present.
Okay.
If that makes sense.
Small question. This is a clear before I make my. I want a point of clarification. Would it be appropriate as all litigation, legal proceedings and meetings? Would that suffice? In council meetings?
Under what, duties?
So under the duties shall be the legal advisor, and attorney for all the office departments of the city and shall represent the city in all litigation, legal proceedings, and city council meetings.
I don't have a problem with that. I mean, I think they're already going to do it, but I don't have a problem with that being in there. But I think what Mr. Lennon is talking about is something very specific. And I think, which is good, that's fine, but I think it's more appropriate in the meetings section to say, hey, look, if this is the type of issue that we've got, we're not going to decide it. We can discuss it all we want, but we're not going to decide it without the city attorney being present.
We don't have a meeting section.
Yeah.
Would that be under quorum?
We have meetings in quorum.
Yeah, we've got something.
It would be under the council.
Council and quorum. wouldn't it?
We'd have to revisit that under meetings and quorum.
Would that require a motion?
We can
we can
revisit
add
it,
it
but it would
under
have to be we would have to be a motion to reopen after, I mean, we'd have to go back after this and go back to that. And that would have to be a motion.
After we get to the end, we go back.
Yeah, Is there anything in this section that we want to be included? We do have an amendment, and we have a second on that, so what would you like to do at this point? Do you still have your motion as is?
So, Mr. Holla, quick question. Is it your recommendation that we put it in underneath the meetings?
I think that's the most appropriate place.
Okay, then I will withdraw my amendment.
Okay. All right. Any other, Mr. Adcox?
I motion that we add in section 7.3 duties of city attorney.
Okay. That's out of order at this point. We will get that out.
Oh, I thought he withdrew his.
Yes, but that section is a different section, right?
No.
Oh, okay.
Duties of city's attorney.
Okay. All right, go ahead.
To revise the language in the first line, after all litigation, go comma, legal proceedings and meetings.
Okay. We have a motion to add comma and meetings. Do I have a second? Mr. London?
I second.
Okay, we have a motion and second. Discussion.
So changing since Dennis withdrew his motion, I changed the motion to add the language as discussed, and then now we're going to be voting on that if there's not any further discussion.
All right. Any other discussion? Any other discussion? Mrs. Sario? Mr. Powers, are you up? Or?
We'll see what she does. Go
Okay.
I'm just curious on this, if this binds him to be in all meetings.
He shall be what that says is that he shall be the legal advisor.
In all meetings.
In all meetings.
So
If there
would
is a
he be
legal
binding to attend all meetings is my question.
No, that's not what that means. It just means he should be the legal advisor of all meetings.
Yeah, because the way I do it here is I come to every regular meeting, and for the most part, I come to most special meetings, but there are times that the council can only meet, have a special meeting on a night where I've already got another regularly scheduled meeting for another client. So, and that, yeah, I think it's a regular duty for the city attorney to come to the meetings, and that's why I won't ever go represent a client that I can't make all of their regular meetings. So if it's a night, like, it doesn't matter who opened up on second and fourth Tuesday of any month, I would never go to apply for the position to be their city attorney because I already come to McLendon-Chisholm on second and fourth. So yes, and I think the attorney absolutely needs to make a commitment to the city if the city wants. Now some cities with other city attorneys, I know other city attorneys, they don't necessarily go to every meeting because the council doesn't want them there. My council's happen to want me at all the regular meetings and as many special meetings as I can go to, and so that's what I do. I go to as many special meetings as I can. Sometimes they go, hey, what about this week and these days, and I try to schedule them. But I'm committed to every client. I go to every single regular meeting of that, and I think that should be in the charter, that your city attorney should be going to every single one of your regular meetings. You got an attorney that, I can only come like once a month, and I don't know why you would want to have him or her as their attorney. If that helps.
Okay. Any other discussion? Mr. Powers?
Not on that item.
All right. All right. Any other discussion? Any other discussion? We are now voting on the amendment. All those in favor, or call for vote. Sorry. All right. Language has changed. Now, Mr. London.
I would like to make an amendment to section 7.03, the third sentence, which currently reads, they shall review and approve as to form all documents, contracts, resolutions, ordinances, and legal instruments in which the city may have interest. I would like to insert after the word form, the words or dissolve all documents, contracts, resolutions, ordinances.
All right. Mr. Halla, any concerns with that?
What was the word, or dissolve?
Or dissolve.
No, not really.
Okay, wait, Mr. Adcox, you.
I will second the motion.
All right, we have a motion, second, discussion. Any other discussion? Any other discussion? To add the word dissolve?
2 words, or
2
dissolve.
words, yeah. Call for your vote. Language has changed. Now we go back. Ms. Powers?
Yeah, I just would like to, on 702, on compensation, I would like to be specific about that and say that the compensation should be the prevailing minimum wage through the term. I withdraw my motion.
Ms. Powers, I'm going to find that out of order.
I was actually going to ask you about that. Is that?
Yeah, we're good. But the chair finds that out of order. All right. Back on. We're at 9:09. I think we're doing well, but I do want to. We do have a lot to go. I would like to try to get us out by 9:30. That might not be possible, but I am going to try. So, but this is important. So, guys, if I'm holding you over, if we need another break. Do we need a break? No. We're doing that right now. All right. Now we're going to go. Any other discussion? Any other discussion? Any other discussion? I call for your vote. All right. Moving on. Chapter 6-9, Chapter 8, City Departments, Fiscal Administration. Do I have a motion? Ms. Wright. We have a motion to accept Chapter 8. Ms. Powers? All right, we have a second. All right, any discussion? Any discussion? Mr. Dean?
Do we already have an Office of Taxation?
So the answer is that is the point of clarity. The way this language was specifically written was that we currently do use the CAD, the Central Appraisal District, and that is by the appointment of that. And the language is meant to do that. So that's why it's written as that, not as originally. Yep. Any other questions? Any discussion? Mrs. Sario.
So, I don't have actual language to do an amendment for this, but I do want to discuss it. Maybe someone else will or not.
Okay.
Section 8.09, bonds and other evidence of indebtedness. It says the city shall further have the power to borrow money for the purpose of construction, acquiring, improving, extending, or repairing of public utilities, recreational facilities, or any other self-liquidating municipal function not prohibited by the Constitution and laws. I haven't had a chance to actually look at the law that would prohibit that, but to me, I kind of feel like I'd like to see some sort of a monetary limit to where it goes to the voter for approval for such things, where it's not just.
Mr. Holla, I'm going to go ahead and provide to you on that.
The difficulty with that is from a practical standpoint. You may get in a situation where you need something, and if you've got a limit on it that you've got to go to the voters for, you may be in a situation where money you need to be spending on something, you're not allowed to, or you're hamstrung by your charter. I'm okay, just like we were talking to him, maybe limit the number of things you can spend the money on, but not necessarily limit the money itself.
Yeah, that's kind of where I'm at, like, just superfluous things, you know, like recreational facilities and stuff like that. I don't think that it should just be like, hey, we're going to go spend this money without taxpayer approval of some sort. But I don't have language for that. That was my thought on it.
Okay.
If anybody else does or wants to.
We're in discussion. Any other discussion? Nope, you're out of order. Okay. Sorry.
I thought since nobody else came.
No.
I was still on. Where would we put that language? Where would we put that language for limiting or?
Oh, I think putting it there would be appropriate. It'd just be figuring out exactly what kind of language you want in there.
I see.
Okay. Now, here's what I would do. I was gonna say, Mr. Lyon, if you would you like, as a courtesy, 3 minutes to see a way to recess to see if you can work a language out to give you an opportunity?
I don't think that would be enough time for me, but I appreciate it.
How much time would you need?
That would be really, more time than we have.
No, what I want to say is, do you think you could come to a conclusion today?
No.
Mr. London?
It's a lot to look at. I mean,
I
we have to
understand.
limit a lot of things and look at.
I want you to have that opportunity, but
The language that we are using here is taken out of the Heath City Charter. So this was, from what I could see, it was nearly identical to the portion that's in there.
yes.
So,
So here's what I would say on this. I don't want to make you feel like we are going to have public forum. We did have it brought up tonight. There still could be that address, and at that point, I think today, unless you have specific language and we can consider as that amendment, I do think there could be an additional amendment later based on public input. So at this time, do we have any other amendments? Any other discussion? All right. I'm going to wait 1 second and call for your vote. All right. All right. Now, notice we did have there, we do have one no, and Ms. Osorio was that no. All right. Very good. All right. Moving on to Chapter 9, Boards and Commissions. Do we have a motion? Mr. Powers?
I don't know if this is a point of order thing, but before we get into motions and amendments and to motions and those kind of things, under Section 905, if we could all look at that real quick.
That is currently out of order.
Okay.
We have to have a motion second, then we'll have discussion.
Okay, I make a motion that we look at Section 9.5 to address an error together.
Before we start?
It's still out of order. Do I have a motion to accept? We have a motion to accept Chapter 9. Do we have a second?
I'll second.
All right. Mr. Adcock, second.
No discussion.
Now discussion, Mr. Powers.
Okay, so looking at 905 together, the first sentence, it reads, boards and commission appointees may serve up to 3 consecutive terms before.
Yeah.
And that begs the question, before what? So something is missing there.
Okay. Yep, I think we can just do a simple clerical that we strike before. Would that be sufficient?
Yes, sir.
All right. Is struck. Any other discussion? Ms. Osorio? Oh,
He had his.
okay. All right, Mr. Adcox.
Section 9.1, where a 2/3 vote of city council be required to overrule the recommendation of the commission. In previous sections, we went from a fraction to
5.
a set number. I would like to see that be 6 for a supermajority.
Okay.
In the fourth from the bottom line on overruling the commission.
All right. So do you, okay. So you're wanting the language to say 6 city council members will be required to overrule? Is that what you're suggesting as your amendment?
That is correct.
Okay. Striking, so I want to be clear on the motion. We have a motion to amend, striking the words a 2/3 vote of council to be changing to 6 city council members shall be required to overrule the recommendations of the commission. That is the amendment. Do we have a second, Roberta?
A second.
We have a second. Discussion. Leslie.
I like where you're thinking. This was the hill I was going to die on. My concern is if they don't have quorum, or if they have quorum and there aren't 6 people here, then we would have an issue with.
That's a great point. I think 2/3 is your point.
And the difference from what we were discussing before was we were talking about how many it takes to want to call a special meeting. But I mean, I'd be fine with making it like 90%, but that's fine.
I think your point is well founded on this.
Yeah.
It makes it more adjustable to the point of those in attendance. So Mr. Hollow, would you agree with that? 2/3
For what?
Vote of the council to overrule P and Z versus 6.
Oh, I mean, you know, we can do that by ordinance. Some people think it's by right, but 212 makes it very clear that we've got to do it by ordinance. So if we want to put that in a charter, it takes 2/3 of the council to overrule say a denial or something like that. Do you want any action of the P and Z? Do you want a denial? How do you want to handle that?
Yeah, I think what this is just to overrule, and I think the language that's being recommended to be changed is to 6 members of city council versus 2/3. The question to you is 2/3 because of it could be that there might be an absent member. 2/3 is the more appropriate action on a decision.
You could say 2/3 of the council present at the meeting. I mean, conceivably, if you've got 4, then it would have to be 3 of the 4, yes. Or 4 of the 6. 3 of the 4, 4 of the 6, 6 of the 7. And then 4 of the 5.
All right. Is there any other discussion on the amendment? Any other discussion on the amendment? Ms. Stevens, you can ask that as a question.
Did he reword his amendment to, are we still at the 6?
We're still at 6.
Okay.
Amendment as is written. All right. Any other discussion? Any other discussion? Call for your vote. All right, the motion fails. Back to it. Any other discussion on this matter? Ms. Wright, out of order.
So I like where we're going with that, a meeting to have a certain number in order to do that. I just think 6 is too many. I feel like keeping the 2/3 still allows that, just knowing the amount of people that come to the meetings regularly and not having it die just because there's not enough folks there. So I would propose that we keep the language as 2/3.
Okay, thank you. Leslie?
I think we're on the same page. I want to clarify the way this is written. It says a 2/3 vote of the city council.
Yes.
So that would imply 5,
Right.
no matter how many are sitting up there that night. So if only 4 show up, they can't vote on it?
Yeah.
Is what we're, okay. That's,
Unless, I mean, if 4 show up, if they want to approve it, they can, whatever, they can basically reaffirm what the P and Z did. But yeah, the way you're written, it doesn't imply, it flat states it. If
okay.
you want to change what the P and Z did, you have to have 5.
Yeah.
So you're right, if they don't show up at the meeting,
Okay.
for what P and Z did.
That's, okay.
Yes.
All right, Mr. Cox.
And so that's what led me to having a hard number on it was, say there's only 4 there, well, 3 would carry it. So for the things, when P and Z recommends denial of something and we have a small meeting for whatever reason and 3 pass it, but the other 4 would have said no, that's why I'm looking for a hard number for that. So if we had 5, if 5 don't show up, they can't vote on it. It has to wait until the next meeting. So it just pushes the item down the line.
No, that would be incorrect.
Would it be incorrect?
Yes, if it does not receive the supermajority, it dies. That's what happens.
Yeah, let's say if P and Z recommended denial of something, okay? It would take 5, and then it comes on a council meeting. It would take 5 council members, the way that's written, it would take 5 council meetings to approve it because P and Z denied it. However, if only 4 council meeting members show up for a meeting and they all vote to deny it, it's denied. They can do that. Because that's why I asked if you just want to do denial or everything. The way that's written, that only applies if, for denial. So what you can put in there, what some cities do is to overturn any action of the P and Z, you need a supermajority or 2/3 or 5 or whatever.
That is what it says. It says to overrule the recommendation.
Okay, I don't have it in front of me. So,
So that is what it says. So it's 2/3 of city council, which is 5, whether there's only 4 sitting there or not.
yeah. Yeah, and the only thing they could do with less than 5 is just affirm what the P and Z did.
All right? Roberta.
Is this by state law? I mean, how do we know if it says a 2/3 vote of the city council? How do we know that means 5? That the city council is 5? How couldn't they sit there saying there is 4
It's
of
2/3.
us?
2/3 of 7.
Of 7. So, but what I'm saying, let's say there's only half of them there at the meeting. They say, well, today it's us, we're the city council, and 2 out of 3 of the 3 that are going to vote it. How does the way it's sitting now imply it's the entire city council? Do you understand what I'm saying?
Because the law.
It really doesn't.
Well, yes. Please restate your question for the legislature.
The way it's written right here, a two-third vote of the city council will be required to overrule. My question is this: let's say only 3 members show up, city council members. Where
You don't
does
have a quorum then.
you don't have a quorum, so it is covered. They could never do this, right? Okay, I'm good with it. Okay, I just want to make sure.
Yeah, no, that's a fine question. Now I understand. So even 4 is a quorum, so they can
Right.
have a meeting, but it would still take 2/3 of the city council, 5, to overrule the recommendation.
Okay.
So you could have a meeting and the council should go there, and let's say the P and Z approves something, and you got 4 council members, and they're going there and have a meeting, and they're all talking like, oh, I like that, I like that, I'm for it, let's vote on it and pass it. They can do that with only 4 members.
Okay.
All right? Mr. Cox.
So just for clarification, in the instance of a denial, 4 city councilmen couldn't go against P and Z's recommendation. It would take a 5th one.
Right, they could affirm, in essence, affirm the denial, those 4 can, but they can't reverse it, they can't approve it, in other words, without 5.
Mr. Powers?
I respect the concerns of my fellow commissioners on this one. Could we just add the word full? Two-thirds vote of the full city council, just to make that overwhelmingly clear?
Well, here's the thing, we've already defined it twice now, what the city council is. So, and it says anywhere in the whole charter, the city council, because that may confuse them. People might say, well, wait a minute, do we have to have all the city council here before we have a meeting on this item?
Okay. Any other discussion? Any other discussion? Any other discussion? Ms. Osorio?
Are you asking about discussion on the whole section or the whole chapter or?
Yes.
Yes, I do.
Go ahead.
I would like a motion for amendment to the section, let's see, sorry, it's the, where are we at? The boards, yeah, chapter 9, boards and commissions, thank you. Would like to add in a section duplicating the park board section for an economic development board with the same language as we have for park board, just changing the words economic development board and making that section 9.04 and then moving the other section to 905 and then adding a 906 to incorporate, to move everything down. Oh, I'd like to make a motion to amend Chapter 9, Boards and Commissions, to add a section including Economic Board of Development with the same language as the Park Board. May.
So we have a motion to amend to add in a new section 904, redoing other boards and commission would become 9.5. And 9.4 would state creating the economic board. Using the... Okay, so right now we have a motion to amend. Do we have a second on a motion to amend? Roberta?
Yeah, I was.
So we're now in discussion. Mr. Holla.
Well, one thing that I think as we grow, and I would suspect we're going to have departments and department heads and, different things like that. We've kind of got finance, we've kind of got the fire chief, we've got a planner, so department heads. I've seen this for 25 plus years in cities of all kinds of different sizes. I've seen it be an issue, and I love Councilmember Brewer's input as well. Having something in there that I didn't see was neither the council nor any members shall instruct or request the city manager or any of his or her subordinates to appoint or remove any person from office or employment. Except for purpose of inquiry and investigations, the council's members shall deal with the administrative services of the city solely through the city manager and shall not give orders to any of the manager's subordinates, either publicly or privately. The city manager shall appoint and where he deems necessary for the good of the city, suspend or remove any employees, and appoint administrator officers provided for by or under this charter. So what I have to do is it's really two groups. It's talking about employees and anybody in part of the boards and commissions. It's probably maybe more appropriate for the city manager portion of it, but too many times I have seen council members telling a city manager, fire this person, do this, or telling a city manager, hey, you need to take this person off this board or commission, we don't want this person on that board or that commission or whatever. Something like that just makes it a very big, hey, you know what, we're not going to have any of that, we don't want to do any of that, we don't want the council going around telling the city manager who to remove from boards and commissions, who to fire as employees, things like that. So just, and maybe it's more appropriate under the city manager, but I just had it in my notes because I know it also applies to boards and commissions. So just a thought on that.
So the way I've always viewed it is on a commission, you serve at the pleasure of the council. And that when you're appointed by them, not the city manager. And I got to tell you, from my perspective, that would be too much power for the city manager. Your people and the people you elect in your city council select that committee. Now, my point on the economic, and you weren't here, but when we talked about the park board, I felt like the economic development board could be created by the council anytime that was needed. I still believe that even the park board isn't a necessary, but we all felt like we want to make that point. I understand your point to that, but I felt that that was the reason why we left it open at that last discussion. Ms. Stibbins.
My only comment was going to be, we cannot mirror the park board paragraph because there are several sentences in there that pertain to a park board only, like civic life, and it talks too much about existing parks, locations for future parks. There's a lot of language in there that cannot be mirrored. So if it goes to a vote, we need to clean up the amendment before we do that. Clean up the motion.
I agree with that.
Okay.
And I was at that meeting.
Okay. All right. I apologize.
No problem.
All right, Ms. Wright.
Mr. Holla, does 904 as currently written, other boards and commissions, allow the adoption of additional boards and commissions deemed necessary as we grow, as we evolve, to be able to identify those at such appropriate time?
I'm waiting for consistency. You said 9.04, right? Oh, absolutely, yeah, the first thing that says it shall have the power and is hereby authorized to create. Doesn't mean that they have to or anything like that. Yeah, they can create whatever board, commission, or committee they want to.
Ms. Saria?
Yes, that's true that they can create them, but giving direction to do this, I find it's so important that we design our city the way we want, and we have some citizens overseeing what's happening with developments, and that we have some citizens going out and seeking opportunities to attract what we might really want to have here, you know, in line with how we live, how we want to live, keeping it rural, more upscale, not just letting all of the drive-throughs set up shop all along the way here. I think some guidance from citizens would be really important. So that's why I would like to see it here if we all agree and want that. So.
Okay. Here's my concern. I think without having the specific language you want to use as the Economic Development Board, as written, it creates an issue that I feel still that 904 currently as written is the best way to move forward with the way that it operates. I understand your concern, but I also think council in going forward, but without having direct language that addresses it, I feel like that would be, we're getting close to I don't mind giving you an opportunity to create that language, but understand that creating government and a board without specific language is acceptable. You're getting into dangerous, in my opinion, it could have a negative effect. I understand your intent, but that's why I go back to 904 and I think that's the importance of discussing with your council. And that's why it's important to elect your councilman. And I hear you, but without that, Mr. London.
So I know we haven't gotten there yet, but later on we're going to have initiatives come up. Initiatives can also be where we can provide some sort of guidance towards the council on what we want to see, and that's when we can bring up, we'd like the establishment of an EDC. So that if we don't get that in here now just because we don't have the language, don't feel like you're being shot down on this.
No. Mr. Sario.
Thank you for that. I'm not really talking about EDC, not a corporation for us, just a committee. because I don't think we'll ever get to the portion of Rockwall where they have a corporation where we're paying people or something like that. Yeah, so I would like to, I could amend and
Okay.
try and put it through here and see what people think.
Okay.
How would you like me to proceed with that?
You have the floor.
All right, I'd like to make an amendment to adding or changing to section 9.04 to place an economic development board in with the language of the city council may appoint a economic development board that shall be composed of not more than 7 members each, of whom shall be a citizen of the city of McLendon-Chisholm. Members shall be appointed for 2-year staggered terms. Such appointees shall serve without compensation. A vacancy and unexpired term shall be filled by city council. For the remainder of the term, the majority of the appointed members shall constitute a quorum, and decisions may only be made by the affirmative vote of the majority of those members present and voting. The Economic Development Board shall select from any of its members a chairperson and vice chairperson. The Economic Board shall be charged with the responsibility for oversight of identifying opportunities for economic development within the city of McLendon-Chisholm. The Economic Development Board may sponsor such other activities for the betterment of civic life within the city, as it shall deem appropriate, and shall have such other duties and responsibilities as may be assigned to it by the city council. The Economic Development Board may make recommendation to the city council for improvements for, let me hold on right there. For advisement on pursuing identified opportunities for future development in McLendon-Chisholm. And if anybody wants to add or
So we
speak to
have a
that.
motion to amend. Roberta, does your motion second still stand with amendment?
I think it shouldn't be under the park board. It should be separate.
That's what she's doing. She's just copying it. That's
Yes.
correct.
Yeah,
Is your second still stand?
Yes.
All right, we still have a motion second. All right. Any other discussion on this amendment? Any other discussion? Any other discussion? Mr. Adcox?
So, could something like this fall under more also of a, I don't know if it would be like a subcommittee of planning and zoning? No?
But way that language could be, I do have a concern that might start stepping on some P&Z toes. The way this is framed, Mr. Hollow, should I be concerned about this stepping on some toes? Because it looks like the language written, if we're copying the park board to feel like this language would almost interfere with the language with P&Z and cause confusion. I know.
If you want to add the economic to the charter, you can, but 9.04 lets the council do it.
What I've been saying. Ms. Powers?
I'm,
I think the park board people will get a little too snooty and full of themselves. You can just take it out and let the council approve them too. Treat everybody equally.
What's that again?
I said, if y'all think the park board are getting a little too full of themselves,
That was my initial point that I brought up.
I mean, there is nothing worse than uppity park board people.
Oh, Lord. I mean, Mr. Powers?
Yeah, I'm on board with you, definitely in spirit and in principle on this, that the city does need such a board. The language that would go in, it starts off with may to begin with, so they may appoint it, and we already have the Section 904 has already been discussed, that they have the power to do that. I think maybe rather than putting in here another thing and being specific about what they may do, that we simply get well, I'm probably out of order by going in that direction. Anyway,
No,
I think probably not. I would be probably not adding that at this time. I would say it probably just go with what we already have, that they can do it, and then find other avenues to make it happen through city council.
Okay.
That would be my thought.
All right. Mr. London.
I was just going to say something very similar to what he was saying over there. And John, the only thing that I took into consideration was I counted up the number of people that we already have on all the boards. And so we have 23 already. This would add another 7. I know that we've got, almost 15 people here, but I seriously doubt, and breaks my heart to say it, that we would get 30 people in total to be able to volunteer for all of these boards and committees at this time. And I'm sure that there's a lot of people, me included, that would want the Executive Development Board to come through. I just think that we may be putting the cart before the horse by trying to put it in here. And if we do the petition, we can get it through as when we have the people. So I don't want to set it up as a failure to start with, unfortunately. I think that's what's going to happen. So no offense.
Yeah. All right. Ms. Cesario.
No offense taken, but in that reasoning, it also sort of makes it, we're saying that those shall have the power to do it, right? But if it's not going to, people aren't going to come forth, and they're not going to create it anyway. So that doesn't really hold, as we're giving them the power to decide.
Well,
so no, I just want what's best for all of us.
I understand. So. Again, my point at the meeting when we talked about parks, I feel like, again, we as citizens have the right to talk and have them hear us. And if they don't hear us, there is a procedure to make them hear us. Okay? And so at this point, is there any other discussion on this matter? We'll go forward. All right. Any other discussion? Any other discussion? I call for your vote. All right. Amendment fails. All right. We go back. Any other discussion on Chapter 9, Boards and Commissions? Any other discussion? Any other discussion? I call for your vote. All right, passes unanimously. All right, ladies and gentlemen, we are 9:44. I'm going to ask you what you want to do at this point. Do we power through, or do we call it a night and we have another meeting? It's bedtime?
Tentatively, when would the next meeting be?
I think I could set it for, probably it would be tomorrow? No.
I think we're kind of in the home stretch, though.
I mean, that's what I'm saying. At this point,
I don't have a lot of things to object to.
all right. I mean, let me ask this, and I'm kind of out of my normal order. Is there anything else that we really? I mean, I think Chapter 12 recall is going to be the next big one. Do we want to try or not?
Can we take a vote?
What do you want to vote? To stay or go? All right. Do I have a motion?
Take a vote, stay or go.
Well, that's nowhere clear. Motion to adjourn or one of the other?
Motion to, continue.
We have a motion to continue?
Yeah.
All right. We have a motion. Do we have a second? Sorry. We have a motion to continue. And any discussion? I'm going to go ahead and call for your vote. All right. That motion has failed. We have another motion. Well, wait 1 second. All right. Do I have a Mr. Powers?
I have a motion to adjourn.
We have a motion to adjourn. All right. I'm going to hold that out because that's going to really mess things up. I'm going to delay that. Before we do that, do you want to modify it so it have a date for our next meeting? Can we do? I do not have a next meeting date. Okay. All right. But before that, is there any recommendation before let's hold off on that motion at this point?
I will not be here. I was going to say, just so you know, on December 4th, Mayor McNeil's having his town hall here. That's a Wednesday.
I was going to say December 11th.
So far, that looks clear.
December 11th? Can't do that?
December 18th?
December 18th? We're getting close to Christmas. What's that? All right.
No, we're not having a council meeting on the 26th. That's correct.
So would you all like to have November 26th? I'm okay with that.
That's just next Tuesday. I would rather go sooner than.
All right. So at this point, Mr. Powers, would you like to try an attempt?
I'm going to let my friend attempt this motion.
Oh. What? He just gave, he's out of order. He hasn't. I'll acknowledge Mr. London. Here you go.
I move to adjourn until Tuesday, November 26th at 6 p.m. 6:30? 6:30 p.m.
Quick question, Mr. Holla, that still gives us enough time, 72 hours, to post the meeting correctly. Okay. We have a motion. We have a, Mr. Powers? We have a second. Any discussion? Mr. McDonald?
I will not be here.
Okay.
Next to you.
Mr. Radcox?
I will not be available for attendance.
All right. Well. Mrs. Soria?
I just want to note that this is a Tuesday rather than a Wednesday.
Correct. This would be a Tuesday.
Which would normally be the city council.
All right. At this point, I'm going to call for your vote. All those in favor, vote. All right. Looks like our next meeting will be set. All right. Ladies and gentlemen, I do thank you for where we're at. We will, and just to recap, where we're going to be putting on our agenda will be Chapter 10, Chapter 11, Chapter 12, Chapter 13, Chapter 14, and Chapter 15. All right.
I'm in California.
You would like to do anything that you want me to do before?
Yeah. Same here. Yep. Yeah, go ahead and return these back so I can use them again. I mean, I have more paper. I just don't have to cut again. We are adjourned at 9:53.
When do we need to do the adding the council cannot vote without the city attorney present? Because legal precedent.
was saying under the meeting section, the